changing lives.
Good evening and welcome to the Law Chambers, where legal matters are discussed from a Christian perspective. I am Anita Delight, and that is season 3, episode 9, right? It breaks my heart to say this, but I still have to go ahead and say that next week and next 2 weeks we are having a campaign, so the Law Chamber will not be coming on, right? So on the 9th of November, we'll be having the grand finale. That is season 3, episode 10. So next week you will not be here, next 2 weeks will not be here. On the 9th of November, that's next 3 weeks, we'll be here to crown everything up with our grand finale. That's not to say that you shouldn't be watching. Please, it's about God's business, you know. So watch and share with friends as well. So today I did promise you that we're going to have a very interesting topic, winding up an insolvency. So the whole season we've been discussing doing business in Ghana. Starting a business, we've done it, the type of business you should go into, if you go into a particular kind of business, the pros and cons in respect to it, where to start, how to start, when to start, the agreement you have to look at, ADR and dispute resolutions, the types you should look into, intellectual properties, taxes, and last week we dealt with foreigners. You know, if you're a foreigner or you're a Ghanaian and you want to team up with a foreigner, what you should be looking out for. We've looked at all that this season. So today we are going to look at insolvency, right, and wind it up. Frankly speaking, you can go up, but what if you start coming down? What should you be looking out for, and how should you go about it? I have 2 guests with me today to help me with this discussion. And when I tell you that they are the gurus in this business, I'm telling you they're the gurus in this business. So please relax, and you know it's live. You can send your questions to 0559680066. 0559680066. Send your questions and we'll be glad to answer them for you. So please go to social media, Facebook, YouTube, Instagram, LinkedIn, you're all there, and watch us live. So let me introduce my guests. Okay, let me introduce my guests. Let me start with a gentleman. Let me just start with a gentleman. He's senior. He goes by the name Lawyer George Kofi Bekai. I hope I pronounced the name well. Exactly so. Oh, English car, Bekai. He is a lawyer and the managing partner of the George Law Consult. He's also the legal advisor to Volta Presbyterian and the Ghana Presbyterian. He's also a lay rep of the Nima district, and he's been in this business for God knows how long. Counsel, how long? How long have you been in the business?
I was close to 16 years now.
Aye. So with your practice, what are you into?
We are more in corporate. Okay. We do insolvency a lot. I'm a legal advisor to the Register of Companies in liquidations and all that. I do their court litigations for them.
Okay.
We do courtroom practice, legal practitioners as we go to courtroom. We do properties, we do trademarks, we do divorce, even we do divorce, everything I understand. I was traveling somewhere.
Adventist church, they say we don't do divorce. That doesn't mean, you see, he's not saying go and divorce. He's saying if you have an issue in terms of divorce, please come and see him.
When I started practice, I said divorce, I won't do it. I won't do divorce.
Same here.
But you see some breaknecking issues that you know, but it's just like you settle the matter. But if you go through the nitty-gritty of it in court, it's going to break you up. Yeah. So you want to divorce, settle.
Thank you so much, Counsel, for coming. Because when I was asking around that I needed the gurus, your name and all these names kept coming up. I'm like, how am I going to get them? How am I going to get them? And God be so good. how I suffered there. How I suffered to get them. Only God. But let me introduce the second person so that's what I'm saying is I'll say it with passion. I have lawyer Audrey Nade with me. She's a lawyer, obviously, and she's also a chartered accountant. She is the managing partner of Audrey Gray, and she's had over 18 years of experience. And when it comes to insolvency matters, or Shehobi, and I remember that the first time I really met her, I had heard a lot about her in terms of the company, the new Company Act, that she was very, very instrumental in helping it be passed. And we went for this program, and the main coordinator was not there. So they said Audrey is going to do it. I need to go and help Audrey. I said, yeah. The company has a crime. I met her. She took me through less than 10 minutes. She took me through, and oh, we did wonders. We did wonders. She's a writer. She writes a lot, and I think one of her favorite quotes is from Henry Wadsworth Longfellow. He says, "The heights of great men reached and kept were not attained by sudden flight, but they, while their companions slept, were toiling upwards into the night." And this, I can tell you, is the summary of Audrey. Audrey,
yes, Anita.
you're welcome.
Thank you.
Hey,
Thank you so much. Oh man, yes, sir.
My chased you for over almost 2 months.
It's difficult, but God has been good.
So Audrey, tell me about your practice.
Okay, so Audrey Gray is a boutique law firm. We're about 5 years old. We specialize in corporate law, in taxation, and in insolvency. We specialize. We don't do everything. We are very young, but we like to believe that we punch way above our weight. We try to do our best all the time, and basically we are growing and hope to be able to compete with the big wigs in the law very soon.
That's so. I heard that when you were helping with the Companies Act and all that, you also helped with another act, the Insolvency Act?
Yes, the Corporate Insolvency and Restructuring Act.
How do you do it? And you're also is it the chairman president of the ACCA?
The ACCA Ghana Network Panel.
How do you do? No wonder I'm not getting you. How do you do all this? How do you combine all that?
So ACCA is, accounting is my first love. It's my first love. So
meaning
I'm a chartered accountant before I'm a lawyer.
Yeah,
so I started my career as a chartered accountant. So I love to give back to that profession. Even though I'm not practicing as an accountant, I love to give back to the ACCA because they made me who I am. So I'm the network panel chair of ACCA for that reason. When it comes to the Companies Act and the Corporate Insolvency Act, I think I had, it's not just me, it was a team. There's a company law committee of experts who actually spearheaded the Companies Act, and I was blessed to have the opportunity to work with them. So I was lucky to be mentored by very, I'll call them legal luminaries in the law, in accounting and finance to come up with those two pieces of legislation. So I'll just say it was God's blessing that positioned me at the right place at the right time.
We thank God.
Yes.
We thank God.
Yes.
So now let's delve in a bit. When we talk about insolvency, Councillor, what is it?
Thank you very much. Insolvency, when you look into the Act, first of all, I will congratulate them for the two pieces of legislation, the Companies Act 992 and then the CIRA. Very condensed, and it's very important. They did very well. That Professor Datobai and Co.
Yes.
Yeah, they
did very well.
When we say a company is insolvent, what it means is that it cannot be able to pay its debts when they fall due. The company is gone bankrupt. Mm-hmm. The company, in this world that we are, when you run a company, you come to the stage where you realize that your funds are not meeting. You have creditors. You have people to pay. There are a lot of constituencies, we call them, within a company. Apart from the shareholder bringing in money, we have the creditors, we have the employees, we have the contractors, we have this. All these people have a stake in the company. So when it comes to the time that you cannot be able to pay your creditors who supply you with maybe raw materials for your coffee, for this and that, then you know that you have a problem. That is, you are insolvent. Your ability to meet your debts at the fall due has come to pass. Then the SIRA, as we call the corporate insolvency, within the from section 1 to 79 or so, is for salvaging a sinking ship, like a sinking company. So they have a situation where you have to go into administration and then see to salvage the situation, as it were, so that it doesn't come into liquidation. Your debts are now over your liabilities. So the balance sheet tilts in favor of your debts. So you cannot meet it. So if you cannot meet it, then you have to find a way of getting people to help you to manage. So those chapters, those sections help you to manage. Then you have to go into what the creditors now, they have those are the people, when the company is insolvent and you're not able to pay, they are the people who are the masterpiece of managing, of making sure that they are paid first when it comes to, that we have the secured and unsecured creditors.
Okay.
So when it comes to the cracks where you cannot be able to pay and it comes to where to manage, they will form themselves into a committee and appoint an administrator. So they will see to maybe ensure that was a very good aspect of, which is different from the at 180, where the company is gone bust, let's collapse it and go away. But now they have to salvage it.
So try to salvage it before
you can. If it can't, then the administrator who is in charge will now go to Registrar General and tell her that I cannot be able to, the situation is so dense that we cannot be able to pay. Then the Register of Companies will apply to the court for it to be put into official winding up. So that is where it comes to the insolvency proper. So you go through a winding up order, a winding up process. That's the process where you have to go through from the one, maybe you go to court if a creditor is not being paid because of the state of insolvency. You apply to the court for an order to liquidate the company so that they can be able to get their money. So you can petition the court, the creditor can petition the court, creditor can petition the Register of Companies, and then even the shareholders themselves can say now we are the end of the waters.
Hey, counsel.
So
that's why you've loaded us.
Yes.
You baptized us.
You haven't told me, so I thought I could.
Let's take them one at a time. Good. So that we know what insolvency we say it means you can't pay your
debt as
your debt. And winding up is when we are really collapsing the company.
The process to go through.
The process to collapse it.
To stop the operations of the company.
Okay, so
formally.
So now what then specifically, straightforward, the difference between insolvency and winding up?
Okay, so winding up happens to everybody. At the close of business, if you are stopping business for any reason whatsoever, you have a duty to the business and to the third parties that deal with you to properly close the operations of the business. This is what we call winding up. Okay. So if for any reason at all, not necessarily insolvency, but if you've done a business for 10 years, you've decided you are tired, you want to get out of the business, the process that you go through to close down the operations of the business, that is the winding up process. So you seek clearance from the tax authorities, you seek clearance from the Registrar of Companies, you make sure that you've paid everybody who you owe. If you're not able to, then you become insolvent, like Mr. Bekai said. But basically, the processes that you go through to shut down your business, regardless of the circumstances under which you are shutting down, that is winding up. Okay. Now, if for any reason you are at the position where you are unable to pay your liabilities when they fall due, then you go into what we call insolvency. So the company is in a situation where they have creditors that they can't pay, they have judgments that they are not able to honor. They have, let's say, suppliers that have supplied goods to them, they are not able to settle. They have goods that are in stock, they are not able to produce. All of these things happen, and then you realize that the company is unable to settle its debts when they fall due. Everybody is chasing them. That is the situation of insolvency. So the difference is, with one of them, you are shutting down the operations of your business. Regardless, you've done business, you want to get out, you are shutting down. That is winding up. Now, when you cross the line where you are unable to pay your creditors, then you enter into the realm of insolvency. And that's what Mr. Bekai was speaking about, where a liquidator comes in takes over the business,
So now
and
let's
then
go
wraps
through
up.
the process proper. So now I'm insolvent.
Yes.
I'm a company, I'm insolvent. Take me through. What should I do? What's the process?
Thank you very much. There are two processes, modes of winding up.
Okay.
We have the private liquidation,
Okay.
and then the official winding up, or the winding up proper.
Okay.
You find a private one under at 992, the Companies Act 12274, where the basic difference between the two is that within the private winding up, you can be able to pay your debts within 1 year. Failing which, it falls into another realm altogether.
Okay.
So what we do is that once the directors of the company who see to the day-to-day administration of the company will do what we call an affidavit of solvency. That means they say that they are solvent, but just that in the interim they can be able to meet their liabilities. But plus or equal to 1 year, they can be able to meet their liabilities.
Okay.
Yeah. So they will file what you call an affidavit of solvency and declare that we are the directors of the company. We have gone to the accounts of the company, and we believe that within the frame of 1 year, we can be able to pay. And
so
then,
if they can be able to pay
within 1 year,
within 1 year, will they still continue with the business, or they'll pay and then wind up?
no. If you say you cannot, you either they are pay they've stopped the business, but the crux of the matter is that 1 year you should be able to pay. Either
Okay.
you're continuing with the business, but the issue is that if you're not, you should be able to pay within 1 year. That is the difference between that and the official
public.
winding up.
Okay.
Yes. So that's why you do the affidavit of
So it means
solvency.
this one, it's more in-house.
Yes.
Yes.
Yeah, that is so.
Yes.
Then you,
Please, are we following?
Yes.
So this one, they are giving you the opportunity to do it yourself within a year.
Yeah, very well.
With this one, the directors themselves are saying that we want to shut down the business. It's not because we can't pay our liabilities. We can actually pay. If you give within the year,
We can
within
be
the
able
next 12 months, we can clear all our liabilities and then shut down the business. So you enter into liquidation. You are not insolvent, you are solvent. And then you go through the process of winding up, which we just explained. And then you pay all your liabilities, seek clearance from all the regulators, and then you strike the company off the records of the registry.
Okay.
That's under the Companies
yes,
Act.
to act to it. Then, having done the affidavit of insolvency, then you pass a special resolution.
Okay.
The special resolution, that is where the shareholders will say, yes, we agree with you, because they will bring it to the shareholders to say that this is what it is, and they have to confirm. So they will pass a special resolution that the company should be wound now by way of private liquidation. Then you name a liquidator within the special resolution, and then the liquidator will consent or accept the fact that I have agreed to be the liquidator. And you add the statement of affairs of the company.
You are getting confused, right? Mr. Mecca, take your time for us. Take your time. Me, I'm getting confused. Take your time for us. Take your time for us. Okay.
Yeah.
So now you are trying to do it private.
Yeah, yes.
Okay. So you've written to
You file the affidavit of solvency.
Okay.
That means you can be able to pay within the 1 year.
Yes.
Then you pass a special resolution by the
shareholders.
shareholders.
Yes.
You pass a special,
So the shareholders will
yes,
pass a special
yes.
resolution.
Special resolution is where you have 75% of the shareholders.
So
saying
you
that
are
they have
saying
agreed.
that you really
Yes,
want to wind
yes.
up.
And there you state that you want to liquidate the company by way of private liquidation.
Okay.
And then you name a liquidator within the special resolution.
A liquidator is the person who is going to help
Yes,
you
you
wind up.
wind up. Yes. And then after that, then you add your accounts, statement of affairs up to the time you are passing a resolution
Okay.
to tell the register of companies that indeed and in fact you have money to be able to pay within the 1 year. And you file that with the register of companies. Thereafter, then the private liquidator will proceed with the liquidation, giving the liquidator information. If you come to the crunch where at the 1 year you cannot be able to pay, you understand? Then either you tell the register of companies I can't be able to pay, so convert it into official winding up. But you go to court and tell the court that we cannot. So give us an order to liquidate. That is private liquidation, simplicity.
Okay. So Audrey, I've done 1 year. I've not been able to pay. What happens?
So if after 1 year you are not able to pay, like Mr. Bekai said, you go into official liquidation. At that point, you completely lose charge of the company. Basically, already in the liquidation, the private liquidator takes control of the company. But when you enter into official liquidation, it then goes to the official liquidator, who would take control of the affairs of the company and then dispose of the assets as much as possible and use those assets to pay off the creditors that she's able to pay. Now, there are a whole lot of complications that go into it. I don't think you can go into it in the 1 hour that we have, so I'll just try and simplify it. So the creditors would set up what we call a creditors committee. That's about 3 to 5 of the creditors who would work together with the liquidator, stay very close in touch with the liquidator, and then try and see how they can manage the affairs of the company to the point where the creditors are paid as much as possible. Typically, by the time you get to an official liquidation, you will not be able to pay all your liabilities. Typically, that's the standard. There are a few that I have seen where we've been able to pay 100% of the liabilities of the company. Yes, and then we've even had a surplus sometimes, but that's very rare. It's not the norm. Typically, you're unable to pay, so you come to arrangements with the creditors that, okay, after we dispose of all the assets of the company, looking at the level of liabilities that we have, and then the sort of creditors that we have, we'll be able to pay. Typically, it's the unsecured creditors that suffer the most. So typically, we'll be able to pay unsecured creditors maybe.
When we say unsecured creditors, what does that mean? Okay,
so the Act classifies creditors into various categories. We have the preferential creditors. Now, the preferential creditors, it's basically employee debts up to, I think, 12 months before the liquidation. You have revenue authorities. You have you have
government agencies.
Yes, you have government agencies. Yes, revenue authorities. You have Social Security, SNET, because of course the employees are very important. You have tier 2 contributions as well, which all go under preferential creditors. And when you enter into what we spoke about earlier on restructuring, there's another class of creditors which comes in when you are trying to save the company. Now, that class of creditors are those that provide financing for you to be able to turn a company around. So we'll get to that later. But with the official liquidation, you have preferential creditors first, who are the government agencies and employees. Then you have secured creditors. Now, secured creditors typically have a security over an asset of the company. Under our securities law, we have the collateral registry. We have various ways of registering securities.
Mortgages.
Yes, mortgages. But the secured creditor would have a security over a charge, over an asset of the company. Then you come down one step more, and then you have the unsecured creditors. These are those that typically they are suppliers, they are people who the company does business on a day-to-day basis. They don't have any charge over any assets of the company. They've just done some form of business with the company, and the company has to pay them and has failed to pay them. What happens in insolvency is the preferential creditors are paid first. So the state agencies are paid first. When there's anything left, the secured creditors would then be paid what they are owed. After that, then we come to the unsecured creditors who get the residue of what is left after the payments of.
So the preferential, the secured, are they going to be paid in full?
Well, it depends on the arrangements that the official liquidator comes to with them. A lot of the time, they come to arrangements which cut down the liability that they are owed. Because of the situation, the company is insolvent. If we pay you 100%, everybody else is going to lose so much. So the liquidator is in a position to negotiate with secured creditors, negotiate with preferential creditors. And a lot of the time, we're able to come to arrangements that allow us to pay lower than what they are actually owed. Okay, so it's not always that they are paid 100%, but whatever they agree to be paid, in as much as possible, out of the assets of the company, what can be paid will be paid. When all of that has been paid, particularly the preferentials, because those are very important, then we come to the unsecured. What typically happens is, whatever is left of the assets of the company is distributed equally among the creditors. Okay, so you get a percentage of what you are owed. I remember the first job I did many years ago, the percentage was 7% of your liability. So whatever you are owed, you get 7%. But what happens is during this period, you are stopped from any legal action against the company without leave of the court. So you can't just, we don't want the situation where you have people running to the courts to file suit after suit after suit. It disrupts the work of the liquidator. So all legal suits are stopped except with leave of the courts, of course. And then the liquidator is allowed to do the work of disposing the assets, collecting the debts back if anybody owes the company, It's also the liquidator's job to go after that person and collect the debts back and then use those monies to pay off the creditors. So the idea is to achieve as much realization as possible and to be able to pay off as much people as possible so that people are not at a loss merely because the company was shut down.
Okay, now
Yes.
let me try. So it means...
What to add? Let me just add before.
Yes.
What is significant of the official one now is the fact that the monies that accrues to the official liquidator is not from a consolidated fund. Is what the asset the company has is what they're going to sell. So if the quantum is big, the distribution, the dividend becomes big. You see. Mm-hmm. So now, if there is a zero net kind of company, you'll be running, you'll be going without anything. Yeah. So what Audrey is saying, what you get after paying all these things, the quantum will be greater if you have. But we can negotiate with the other creditors and see whether we can be able to, because what is significant is that the government agencies, they would like to take their money in full.
Mm-hmm. Yes.
You understand? Yes. And then in all the cases, you have to apply to stay proceedings of all inaction against the company, and the law requires that. You see, so it is.
So let me come from the direction of, let's say, for example, you are watching us, right? And you've listened to all that we've said so far, and your question is, if I'm a creditor and I want to be secured, what do I do? How do I secure myself so that if should the company wind up in the nearest future, even 10 years time, I'm secure?
You can be safe, yes.
How do I secure myself?
I think the banks and financial institutions are very good at this. Mm-hmm. You take a charge over an asset of the company. You take a charge over an asset of the company.
Take charge.
So if the company takes, if you have let's say a 500,000 cedi business with the company, you give them 500,000 cedis. You say, okay, you own this landed property at Abokobi worth about 600, 700,000. So I'm going to create a charge over that property. That property now is, even though you are using it, the legal ownership of the property eventually comes back to me. So you can use the asset to work, but that asset belongs to me until my liability is paid back in full. That simply puts, that is the
Please,
charge.
we get it right.
Yes, in regular English,
yes.
That's the charge. In simple English, it's a bit more complicated, but really that is what it means. So you create a charge over the assets of the company. But what I always advise creditors, people who deal with companies, is you yourself dealing with a company as a third party, you should make it your business to know what the company is up to. Mm. You should try to understand the business of the company. You should try to understand who you are dealing with, who are the people, who are the directors of this business. Are these credible people? What is the business doing? Do they owe so many people? As I'm going to do business with them, do they already owe 10 other people that they've not been able to pay in, let's say, 6 months? Or are these people that are able to meet payments when they fall due? It's your business as a business person to know who you are dealing with, who you are doing business with. Something that we take for granted a lot. That's, I work closely with the registrar as well, so I know she's always pushing people to file their annual returns. We take it for granted, but it's important to check if companies are actually filing their annual returns, because it's one of the telltale signs of insolvency. If a company is not able to file their annual returns at the time that the annual returns are due.
The audited accounts.
Yes, the audited accounts. They're not able to file it when they are due. Or they file the audited accounts and these accounts they are not accurate. They're not an accurate representation of what the company is doing. It's a telltale sign that this company is either insolvent or heading towards insolvency. If you hear about so many court cases against the company, I'm not going to use my company because words have power, yes. But company B is in court with this person today. The next day you hear they're with this person. The next time it's another person taking them to court. That is an indication that you should not do business with that company. Because if you have 10 people taking this company to court for monies that they've not been able to collect, why would you then go and do business with such a company? So it's the business of creditors, of third parties, to make sure that they understand who they are doing business with, what the person has been up to, the other businesses that the person has been involved in, particularly the directors. What have the directors done before? Were they involved in businesses that collapsed at some point in time? If they did, you need to exercise a bit of caution in dealing with them again. So it's important that third parties dealing with companies take interest in the general. Of course, you can't know the interior acts of a company, but you can see publicly what is happening with that company. So take an interest, learn what is going on before you start to deal with them. Or if you realize that at a point they are struggling to pay you, they are doing this, they are always having issues, you quickly try and recover your monies before the company goes down, because that is another telltale sign that they're on their way out. So we need to be careful, and we need to start following the rules that have been made to protect us. Don't think that you can avoid the rules and then avoid trouble later on, because you will meet trouble.
So what's the school of these people who are always of the school? They think that I can work with the government. The government will take sometimes 3 months, 5 months, 10 months to pay, but the government is permanent. So although there's when it's due, they don't pay, they can't pay. Still, I don't mind working with the government. What do you think about that?
The government is there, but if the government owes you, that's what I want to say, and the government is not able to pay.
Yes, it happens.
Yes.
So sometimes a year the government has not paid. They tell you it's not gone through the process.
And that will affect the liquidate, your liquidate, you going into liquidation.
But most people don't mind. Some of these they don't mind.
Government money is secured. It can take ages, but it will come in the quantum that you deserve. The only thing is you apply your interest on it. You understand? So that is it. But let me come to...
I'm of a different school of thought.
Okay. Let's have your school of thought. Then we come back.
Let's look at what Audrey said. Let me add a little bit.
Okay,
especially the banks. They are still very good.
Yes.
I've done cases at Registrar General where the bankers will give a debenture, give a loan, and then they will not come to register and take a mortgage certificate. That makes you a secure creditor. If you give money and all that and you are devoid of this certificate from the register of companies, you'll be in trouble when your company goes insolvent. Secondly, they will do a mortgage and they will not even go and stamp it at the Lands Commission. You understand? And you go and you take someone to court that is a debtor. You understand? You file as a defendant. You are claiming so much. And within your witness statement and your filing, it detected that you have not even paid your stamp duty on the mortgage, agreement. You understand? So when the company goes bust, you are not a secure creditor. Why? Because you have not even paid the stamp duty on the subject matter by way of the document. You see? So it's very important that to be secured and properly so-called. And that is why it is very good for you to do it, because at the end of the day, you don't know how the company will run, whether it will go well or not. So you need to be secured. So creditors or any business in Ghana and all those that do business and all the banks that loan, give monies to the companies, they have to also examine the accounts of the company to find out, as Audrey is saying. Because in the eyes of the law, the third party will not know that the company will go bust or whatever. You do business with it anyway. You don't need to ask whether the nature of business that they are doing is actually within the special resolution of the company or within the company's books that they are doing ABC. Yours is to transact the business. But if you don't check by way of visiting the register of companies and finding out, as she's saying, your accounts, you see that they are in deficit for so many years and you want to put in money as a director or as a shareholder, you'll be in trouble.
Okay. So Audrey, the second school of thought.
Oh yes, on government liabilities.
Yes.
I think we've come to a place where we have seen that the government also has problems. It has its own problems. There's something called sovereign debt, sovereign insolvency, which I'm not saying we are there. Maybe we are not. I don't know. But I find that in dealing with the government, like Mr. Bekai said, government contracts tend to be good and very
lucrative.
Profitable. Yes, lucrative. But the time between what you invest and what you are going to, the returns that you are going to get could be 1 year or 2 years. Do you have the capital to tie up for 2 years? If you do have the capital to tie up for 2 years, by all means, go for it. If your risk appetite is such that, okay, I can do this and wait for 2 years to be paid, and it's not going to affect the liquidity of your company, then please go for it. But if you know that after 6 months, 1 year, you're going to be looking for money to be able to fund your own activities, then it may not be the best option for you. Let those who have the liquidity to be able to wait for the 2 years do those sorts of jobs, and you try and do the little that you can to sustain yourself. Because so insolvency, there are 2 ways of measuring insolvency. There's the cash flow insolvency, which is where you don't have the cash to pay your liabilities, and then there's the balance sheet insolvency, where your net assets cannot fund your net liabilities. If you get into cash flow insolvency, where your liability, you don't have enough liquidity to fund your day-to-day, creditors will come after you and they'll shut you down faster than you can say jack. Instantly. They will shut you down. So if you are doing a government contract and you know that cash flow-wise, you don't have the liquidity to be able to finance yourself for the 1 year or 2 year layaway time that you have to, please stay away from it, because you will find yourself shut down before that 2 years comes for you to collect your money.
It becomes. I think that the banking crisis, we've seen it's a best example.
There are a lot of
inter
how do you call it? They will deposit money here.
Yes,
Inter-depositing of
you
money.
need to be careful. You need to be careful. And we say government contract, we say it's excellent, but it's not for everybody. Not everybody has the liquidity or the capital to be able to finance them. So let those who can play in that field play in that field. And then you who are smaller, who it could affect your liquidity or your cash flow in the short run, do what you can do to maintain your cash flow and to maintain your business. Don't put yourself into a fix where you have creditors coming after you because you have funds locked up in one government contract, which is what we see all the time. Okay. You see other viable businesses, the business would have been otherwise viable, but because they have all their capital locked up in one business without any alternative way of getting financing for their operations, they end up insolvent. And the insolvency would be halfway through before the money that they're expecting from whatever contract comes through. So what have you done? Have you gained or you've lost? So we need to be careful. As business people, we need to be cautious of what we invest our money and our time in.
So irrespective of the kind of business, be it sole proprietorship, be it limited by guarantee, we go through all the steps are the same.
No.
The sole proprietor in terms of liquidating.
Yes.
Our sole proprietor is representing yourself. You see, so you will come and say that. But in the first place, you have to be able to renew your business with the register of companies, all that. And then you have to know you don't owe the government any snares, tax and what have you. So having gone to that conclusion, then you come and you can write to the register of companies that I want my company to strike out. But you have to bring all the accounts to show, because under no circumstances you owe anybody if you want to go into liquidation or you want to go into a private liquidation. For official liquidation you can owe.
So what happens to those people who will not even wind up winning? They just run away.
So what
happens to their business? What happens to them?
Because in the first place, you can strike out a company without dissolving it. You understand? There you don't owe anybody. There is no asset, no nothing. Then you can just write to the official liquidator that strike out the name of the company. But there they have to investigate and find out whether or not you were working. They will give you a notice and find out whether you are working. A second notice. So the third notice about 3 months, then your name will be struck out. That's a simple striking out of a company without dissolving. Dissolution is where you go through the process of liquidation, whether private or what, to get it done.
If that's the case, why won't I just wait for them to just strike it out? Why would I want to go through?
If you don't owe anybody.
I owe, but I'll run away so that they'll strike me out.
You see? Because
are there any repercussions?
Yes, there are very serious repercussions for that. People do it all the time, but under our old regime, under our old law, before Professor Datibari Fiajo and Co came up with our new Companies Act, you can get away with that, maybe. But under our new regime, if a company goes insolvent while you're a director, so you're a director of the company, most of the time in our company structures, we have the shareholders, same as the directors. You realize that they're the same people. If you're a director of a company that goes insolvent, the Companies Act has bars on you becoming a director of another company For a period of time,
5 years.
yes. For a period of 5 years, you cannot be a director or a senior manager of any other business in Ghana. Yes, you cannot. You are barred for it for 5 years. If you are a director of a second company that goes insolvent, that 5 years is extended for a further 5 years. If it happens a third time permanently, you cannot be a director of any company in this country. So there are very serious repercussions. We also have laws against fraudulent trading, where we are able to lift the veil of incorporation. And for, typically...
What does that mean?
Typically, in our business environment, if you are not a sole proprietor or a partnership and you're a company under the Companies Act, you are separate from the company. So you have Audrey, and then you have Audrey Gray. Audrey Gray's liabilities belong to Audrey Gray. Audrey has nothing to do with them. Audrey's liabilities are mine. So if Audrey Gray owes you, you cannot come after me, Audrey, my personal assets. I can have a house at Trasacco Valley. You cannot come after it. Audrey Gray owes you. I don't owe you. We are separate. But the law recognizes us as separate people. But if I have done something fraudulent, you, a creditor, can get the court to lift that veil, the mask that separates me from Audrey Gray. And then you can come after me personally as Audrey to pay off your liabilities.
And I'll come and take your house at Trasacco.
Yes, when I get it, please. But you can't have it. No, you can't have it. You can't have it. But the law has provisions to protect third parties that are trading with certain companies. So it's important to always seek professional advice, so that at least you know what remedies are available to you, and know that people cannot just get away with doing business as usual. They can't just get away with shutting down and disappearing. Yes, the registrar is setting up a service. She's going to have inspectors who are going to be able to go around companies, enter into your company, and see what the company is actually up to on a case-by-case, day-by-day basis. So it's going to become more difficult for people to get away with some of these things.
So what happens then to the company, the debtors? What happens to them?
The debtors that owe.
Yeah, the people who owe the company. Now the company is
gone bust and all
and
that.
it's winding up. What happens to them?
That is why you have the accounts.
Okay.
It will show you the creditors, the quantum of the creditors, and even the under the Act 1015, the liquidator will have the power to appoint accountants to examine. So if you bring a quantum of money like you want, you have to prove the debt that you've submitted as your claim. So they'll subject it. You see that what you brought may be lower than what is in the books. So that is why the statement of affairs is important. So they will examine the statement of affairs and then juxtapose that with what you have brought to show that the company, the books of the company is how much you owe, and that is what you brought. So they will settle with you and then arrive at that. You see the list of the debtors. There you have to hire the services of a lawyer to go after them. Because once you are going to pay creditors at the backlog, the backlash, you have to also pay the debtors will also be brought into the books to be able to be paid. So you have to get them. And this is what happens. Where to find the debtors can be a problem. To even sue to recover. You see, so as the debtors are pulling you up, you on the balance sheet that you have to balance it up with the debtors, you cannot get. So it becomes a problem. So the companies, bookkeeping exercises, they don't take it serious.
Kasha, are you listening? Your books.
Your bookkeeping.
It's very important.
Instead of hiring a correct accountant, qualified accountant, they'll find an accounts clerk, and whatever the work that they will do. Now, if the auditors are coming, they have to now do the accounting before they do the auditing. You understand? So that is why they can't be able to file their audited account. The account that they will bring to Registrar General will be different from the account they sent to, how do you call it? GRA. You see it. So, if you are not able to put these things in place and ensure that now debtors have to be chased and to be paid, you can't get them. But let me add also that GRA has an eagle eye. If there is a publication from Registrar of Companies or any other body that the company is in liquidation or private liquidation, they will chase you from the papers. Their eyes are there.
And everywhere.
Yeah, if they can't chase you when you are gone, as you are saying, they can go underground. No, when the publication comes, they will fetch you up. You see, so companies have to put up a very good governance system to be able to prosecute what they are doing, so that at least they don't find. It's because of these governance system that sometimes they find themselves going aground.
I'm supposed to summarize it in three. Yakasa bebree. Na in a nutshell, that me can say, yaka bebree and say o business ni nko yi na ye gua. You betimi ama 1 year. Say she so betimi at 2 year. When that happens now. Okay, so let me. Are you good with tree, sir? Tree. Okay, summarize it in under 2 minutes. Summarize it for us.
Yeah, I can say ubi our company. One person person do be a person good company na. No or quite say ube catch registrar general. So it's a good company. But the accounts no never batch say new be a car. No one share ubia or your liquidator na accountant. Or your lawyer na accountant. No, uncle good company mao. O the car is so tia as an good company no. Now when ultimate tia o can swan. So ultimate eba register general na so now ne beka. And now men train will be credited me for uncle court. Because all the court are then agin some way. Enti bomodi say adwuma na wo ye no. For professional, so ye company MD na be fanon. So ultimate MD hwehwe MD ono na adwene mda ho. Na hwe accountants papa no ultimate hwe wo assets ni ye. Omo do ka nyina no tresi wo mo naje na fa be ye company no so trans na ultimate hwe company ni ye a engu wo na so e na wo ye company so a don't be fraudulent men ko ye kulululu because ye chiwa another sec and then the Companies Act no ultimate ye director BIBO papa BIBO Ghana director of a bank now they have to go to scrutiny by the Bank of Ghana before you can be a director of a bank. And ni na ye corporate governance ye dia bantu ye adwuma hwedwuma no so ye
na paper mo nsam
paper ukoye se bia we one man business for personal money no ensure company no na akoye check ni show bottom na akoye you do na send checks so one man business kra no sika obenya no fa ko bank wa register company no you get a certificate ko bank be account amount you separate the money from your personal account no if you company account no so the schedule obenya na the company name na o books no annual returns no nyama nyina no hweniye na paperwork in the corporate world no is very important and yes I go a nyankrofo do kakra hu no akohwe o majo msika.
That was a good tree. I mean, 3 minute fan. Please let's go for the short commercial break. We'll be right back.
As a small business owner, Mitaisha Business Forum, our Hope channel, it really helps me with my business.
Don't let your priorities be because obi eye bibinti. Also we share some why one kasa sawasa. So we jani niya we biani.
Okay.
Obi ani need so that unko fa problem ma was.
In the first place, business a risk.
Okay.
It's just all about risk. Now pursue your business, so now you need you should be a risk taker.
Okay.
I would recommend it to you to Mesresa Usu Beshebi.
Welcome back. We don't have much time. 1 hour and so you try, sir. So now let's say you are struggling, okay? You don't want to go under, okay? But the company is struggling, and you don't know what to do. How do you go about it, Audrey? Save my company.
Okay, so under my baby law, the SIRA, there's a very important provision called administration. Okay. Now, administration has been placed in to be able to help companies that are struggling but that have the potential to come back from a place of insolvency. So if your company is struggling, you're not able to pay your liabilities, you have creditors chasing you left, right, center. Sometimes all you need is a little bit of peace to be able to restructure the company. So now the company, the CIRA has provided, gives you a break the company to try to turn it around. So this insolvency practitioner is empowered to actually be able to go out and to try and source financing, which we call post-commencement financing, to put into your company. And then if your company is viable, then the company can turn around, hopefully. So you get an insolvency practitioner who would come in, who would assess your business, who would see whether the business is potentially viable, and who would come up with a plan, a restructuring plan, which we would use to help to turn around the company. Now, the insolvency practitioner, in this particular case, they would work with the creditors hand in hand. The creditors will form a committee who would work with the insolvency practitioner. They would accept the restructuring plan, so everybody would be on board, and then the insolvency practitioner would go into implementing the restructuring plan to try and turn your company around. If the company is able to turn around and he's able to pay all the liabilities that you owe, then the company will be handed back to the directors.
Okay.
Yes. But if the company is not able to turn around, then the company would go into liquidation, and then we would shut down the company completely. But at least administration offers a gap between solvency and insolvency to allow you to try and restructure the company and turn things around if your business is potentially viable.
I think that's a good one. And
yes.
And do people use it?
Yes, it's excellent. We are currently working on an administration. I'm working on administration myself. There have been, I think, 2 that I know of that have gone on in Ghana. Some of them have gone into insolvency. Our laws are still quite new, so it's been quite a challenge to source financing. But I know that the Insolvency Association is working on a strategy to be able to come up with a fund to help companies to get financing during the administration stage.
Oh, okay.
Yes, so if your company is viable, you find an insolvency practitioner who knows what they are doing, who can come into your company, take over. So they take over the seat of the directors. The directors lose their power. They have 0 power at that point. The insolvency practitioner has complete power to try and restructure the company. And then if they are able to, the directors get their company back. If they are unable to, we go into liquidation, we shut down, we pay what we can. So that option is the middle ground that has been put into our law.
One,
yes, yes.
And so it means that this person coming in, it should be someone you trust, or it should.
Okay,
how do you
so
choose
the administrator.
Yes,
the administrator. The law has a qualification for the administrator. So the person should be a chartered accountant, a lawyer, or a chartered banker, and a member of the Ghana Association of Restructuring and Insolvency Advisors, and someone who has been licensed by the Registrar of Companies to do insolvency work.
Okay.
There are people who are trained to do this sort of thing.
Okay.
So if they are licensed, they are trained, and you believe that the person has the skills to be able to help your company, you get the person in and they assist. What I find, though, is a lot of the time in administration, the directors may take, they are supposed to take a back seat. But if you want to support your business, you should be able to help whenever the administrator calls on you for support. You help so that you are able to help to turn things around. If the company is able to turn around, it comes back to you. It's yours. It's your business. If it's not able to turn around, it will be shut down. So it depends on where the business is. If you wait for you to get so deep into the debt hole before you seek the help of an administrator, at that point it's too late. Yes, it's too late. So once you start seeing the indicators of insolvency, you quickly go out and look for help. If you don't need an administrator, they'll tell you you are not at that point yet. But if you do, early intervention is the best option.
And to add
it's
to
very,
that,
very important.
Yes, when it comes to administration, the creditors play a very critical role. And then they will help, they will even meet and see that and tell you that we need an administrator. And they will appoint somebody and then see how it goes. If it doesn't go on well, then they will do what we call a watershed meeting and tell the administrator, no, either we change you or we collapse the company is shut out. So you have to relate with the creditors because they are the people who are superintending over the issue or the fact that you are not able to pay your debt. So they have the balance sheet is in their pocket. So now you have to relate with them and then see how you'll be able to, they can even source the funds for you
Yes, in some cases, the
Yes.
creditors,
Yes.
in fact, in some cases, the creditors, particularly the banks, they are able to provide additional financing in the form of post-commencement financing to turn the company around. And that's the first rank in insolvency, which I said we would come back to, post-commencement financing. That's money that is provided to turn a company around. A lot of the time you find that the banks and financial institutions can do what they call refinancing. So they'll provide the administrator with more money to be able to turn things around. And like Mr. Bekai said, they are working with the creditors. The creditors are involved in what is happening. They know that this is what we are doing, this is the plan, this is how we are moving forward. So it's a collaboration between the administrator and the creditors to try and turn things around for the benefit of everyone.
This is interesting. Charles Crunchy said, God bless you. God bless you too, Charles. God bless you. Eden said, I have a company. We are not doing well. I want to fold up. How do I start? Where do I begin from? We've already told you where to begin from. Susie, are there banks, individuals who can help you run your company if you're having challenges and wish to fold up? How can they revamp? We've just spoken administrator. We just spoke up. Can there be any decency when winding up? So the person, I think that the person thinks that winding up is a shame. So how do you protect the dignity
Of the shareholders or the directors?
Or the directors.
When you are folding up? Because he said sometimes published in the newspapers, their names splashed, or sometimes their picture. Is it possible to protect the dignity?
But we don't. When it comes to insolvency, what they publish is that
You
publish this company is in liquidation. Unless of course people know that you are the MD or you are a director of the company. This company is in liquidation. All creditors must submit their claims, and all directors or all the debtors should be able to pay their debt. You know, there will be series of adverts. Unless they know that you are there.
You are.
But it's a business we are running, and you want to sanitize the system. That is why when you go to Securities and Exchange, as you are saying, they have to prove. You have to prove you as a director. You know, maybe they will ask you to go to the CID headquarters to get a criminal record for them. You want to be a director in a bank. The Bank of Ghana will have to certify you. You understand? So these are the areas. So if you are not able, you say that you are qualified, and directorship is a trade. What it means, that's a profession that people take and make sure that they run. So if you are not able to, you are not looking at whether shameful or whatever. It will be there as it is, because you were not able to in the first place. But nobody, unless there's a fraudulent dealing, as you are saying, that they will be lifted. Yeah, the in-house dealings and all that. When the veil is lifted, they will come after you in person. Yes. So you're a director, you go to your board meetings, make sure that you look into the books well, and then it doesn't fold up on your hands. If not, you can be taken on when there's a chaos.
Yeah.
Or
So your final words, your advice. What would be advice?
How do you take it first?
I would advise that if you are getting involved in any business venture whatsoever, there are classes of businesses. There's the sole proprietor, there's the partnership, there's the company limited by law and by guarantee. Limited liability companies are not for everyone. Sometimes the compliance standards are too high for people to meet, and that alone runs them into insolvency. So please decide the sort of business that you want to do very carefully. Secondly, if you're a director of a company, let's not go and sit in the boardroom and just to tick a box. It's a very serious business. Yes, and take the fees and actually provide zero value. It's a very serious business, and I think that directors should get to the place where they take their jobs seriously. They take their duty to the companies very seriously. We spoke about shame earlier on. There is no shame in failure. If you have failed in a business venture, there's no shame. Have the company liquidated, start again. But if you're afraid of shame, which is what we find a lot of the time, you stay in the business and you continue to run yourself deeper and deeper and deeper into the hole. Why? Because you are ashamed that people would know that you failed. But there are opportunities for you to turn around the business if you step forward early enough. So please, let's forget the shame and let's realize that we are doing business with people. We are doing business with third parties who are trusting us with their business and sometimes with their lives. People invest all their monies into people's businesses. If people have given you that level of trust, show yourself also worthy of that level of trust and do business in a way that protects you and that protects your third parties as well. If there's a problem, go forward and look for help. There's the Association of Insolvency Practitioners that is available to recommend an insolvency practitioner for you. They're able to give you support as to how to even go about trying to help your business. Seek legal counsel. Mr. Bekai does this, I do this. There are so many lawyers and accountants and bankers who are in the industry who are able to support you. But don't stay quiet and watch your business collapse. It's better to seek help and to try and turn things around. And if you fail to liquidate the company in a respectable manner than to wait to go completely insolvent and then you have everybody chasing you, everybody mentioning your name. And if you are not careful, you would have the veil of incorporation lifted and you lose your personal assets as well. So let's understand our rights as business owners. Let's understand our rights as customers to businesses. Because like I said, it's the creditor's responsibility as well to know. And even as employees, let's understand what we should be looking for within our businesses and how we can also support our businesses to grow. When companies grow, it's good for the entire economy. It's good for all of us. So together, let's try and help companies to grow and not be part of the problem and cause more companies to collapse. So please, know the law, understand the law, let the law help you, and let the law work for you.
Amen.
Thank you.
That's a good one. You owe me big time. Please send me more because I've done a good work. Mr. Bekai.
Yes, it's very important that, as Audrey said, you're dealing with business. You go to Europe, you go to America, companies are over 100 years.
Yes.
Yes.
Ghana.
Yes. Yeah. The MD who has the sole shareholder has a check in his pocket, dishing it out as though there's nothing. Okay. Now that SEC has set up, now you see that the companies are sitting up. Now directors will not have a field day because Bank of Ghana are watching the banks. The directors, there's a whole document on the, how do you call it, code of conduct of all the directors and the managers in Ghana. Look for the code and perform creditably.
Wow. So let me just summarize this by saying that before I say we feeling, me can say feeling. Me do hono. You will say ye company na ekofoma. Me ntwe ma na nkofom na enwie. Ye wonkrofo bi o me company na ekofoma. Me ntwe ma na nkofom na enwie. Ye wonkrofo bi o metimi aboa o ama o company na samba subio. Ti me ntwe ama o company ni ngun wie ansa wa be hiamboa. Start say gu na ye wonkrofo mo wo ho. O metimi aboa ama company no I'm take you over na company na ye biom ama wo ama ye nina. And so let me just say these final words. Please, as I said, next week we are not coming, next 2 weeks we are not coming. We are coming back next 3 weeks. And the idea is that we are having a program. So on the 9th of November we'll be crowning the whole program season up with our grand finale. And the topic we are going to discuss corporate business and ethics. The whole idea, and they say we are business no morality wo he e say nyame bi wo he say ye no nye and everything goes, everything we are supposed to do some. How do we go about this? On the 9th, next week we are not coming, next week we are not coming. On the 9th of November we'll be discussing that and we'll be crowning, using that to crown the whole season. So until then, please let's watch Hope Channel, let's help broadcast the program and make sure that at the end of the day, as I always say, you've learned something, anything at all. That's what I want. All right. So until 9th of November, please stay safe and God be with us all. Amen.
Amen.